everyone, welcome. Thank you so much for coming to this HLS PILAC event. We're really excited, and I know many of you in the audience take a particular interest in this issue. So I will take very little time with introductions so we can get right to Chiara's presentation. Dr. Chiara Redaelli is a visiting research fellow at Harvard Law School this semester. She is also a research fellow at the Geneva Academy, where she works for the Rule of Law and Armed Conflicts Project, the RULAC project. She formerly worked with the UN High Commissioner for Refugees in Cox's Bazar and Beijing, and she recently very successfully defended her PhD in public international law at the Graduate Institute of International and Development Studies in September 2018. Her doctoral research, part of which she'll be talking about here today, looks at how the human rights paradigm has affected the international legal regulation of interventions in non-international armed conflicts. As many of you know, the topic for today will be looking at military interventions in non-international armed conflicts, particularly those framed as being by intervention. So we'll have about 25 to 30 minutes of talk, and then we'll open up for questions and comments. Thanks and welcome.
Thank you so much for having me here, and also for giving me the opportunity to speak about this topic, which I found very fascinating. And every day, basically, we hear new interventions which are justified based on the invitation of the government. So I think it's also a very timely moment to talk about it. So the thing is that, let's imagine that you have a democratically elected government, and you have the president that, due to civil unrest, has to leave the country and to seek refuge abroad. And let's imagine that this president then asks for a foreign intervention from the host country in the home state in order to regain control. Now the question is, how would you identify this situation? Would it be lawful under international law or not? And over the last years, we have had two instances when this has happened. On the one hand, we have had the intervention of Russia in Ukraine upon invitation of President Yanukovych. And then on the other hand, we have the intervention of Saudi Arabia and Yemen upon invitation of the president. Now, in both cases, we have very similar situations. However, the reaction of the international community was really the opposite. So on the one hand, in the case of Ukraine, the international community said, well, this is unlawful because Yanukovych is not the lawful president anymore, and therefore the intervention should not have happened. On the other hand, when it comes to the intervention of Saudi Arabia in Yemen, we see that the international community, generally speaking, accepted as lawful the intervention in the civil war. Now, the question is, what does it mean when you have two very similar situations and the international community react in two different ways? Does it mean that the rules are so unclear that basically states can do anything they want? Or does it mean that there are some rules and that states just don't care about them and they decide to violate them? So what does it mean in practice when you have these situations? So the objective of this presentation is actually to demonstrate that, first of all, we can identify clear rules when it comes to interventions in internal conflicts. However, it's also true that there are new trends that are emerging in the practice, and we are going to see whether these new trends are going to change, or whether they're actually changing now the legal framework regulating interventions in internal conflicts. And if we think about interventions upon invitation, at the end of the day, the real question we are trying to answer is, who is the government? Who is in charge of inviting a foreign country to intervene in a civil war? And this is particularly difficult during a non-international armed conflict, because obviously in a non-international armed conflict you have at least part of the population which is challenging the president, the government, the authority, and therefore is this president, this government still capable to speak on behalf of the state and invite a foreign country to intervene, to regain the power? So in order to answer to these questions, we are going to see, first of all, what the scholarship has said so far about interventions in internal conflicts, and when we're going to see whether these traditional approaches adopted by the scholarship can be confirmed by looking at state practice, or whether there are new trends and different answers that we can give. So when it comes to the traditional approaches, we have three main positions in the scholarship. On the one hand, there are some authors that claim that interventions in internal conflicts are always unlawful. And this is the abstentionism approach, and the only exception that they accept is when it's the case of counter-intervention, which means when you have a state which is already helping the rebels, then in this case another state can intervene in favor of the government. But outside this specific situation, it will be always unlawful to intervene upon invitation of the government. Now, the legal basis provided by the authors that support the abstentionism approach are twofold. On the one hand, they say that an intervention in an internal conflict would violate the principle of non-intervention in internal affairs of the state, because obviously, it's quite easy to understand how a non-international armed conflict is an internal affair of a state, and therefore there shouldn't be any interference from outside, from an outside power. And the second legal basis is the principle, the right to self-determination of people, because if a people has a right to determine its own political destiny and the form of government they prefer, then if you have an intervention from an outside force, then in this case, this outside force is going to interfere with the expression and the exercise of the right of self-determination of the people who are fighting against the government. And so for these reasons, these scholars claim that interventions should never happen unless in case of counter-intervention. Now, the problem with this position is that if we look at state practice, we see that that's not what the international community say. Even if we could agree in practice, in theory, that an intervention in an internal conflict should not happen for these reasons and for these legal grounds, then in practice the international community doesn't seem to believe that an intervention in an internal conflict will be always unlawful. And if we look also at the state practice and the discourses within the international community, we see that the main issue, as I mentioned before, is actually about who has the authority to speak on behalf of the state and to invite a foreign country to intervene in an internal conflict. And to answer to these questions, other scholars have suggested two approaches. On the one hand, we have the abstentionism approach, which the effectiveness approach, which basically says that a government which has effective control over the territory and the population has the power to speak on behalf of the state. Now, it's easy to understand why someone would propend for the effective control as a criterion to identify the government, because obviously it's something very concrete and practical. But the problem here is, what is the threshold of effectiveness which is required? Does it mean that the government has to control the capital? Does it mean that the government has to control at least 50% of the country? And how do you actually identify, what happens if the government today loses control over the capital and then tomorrow regains control? Does it mean that you keep changing the recognition of the government all the time? So this is one of the first issue when it comes to the effectiveness approach. The other issue is when you have a criterion which is only based on a factual ideas, effective control, basically you're endorsing a might makes right approach, whereby you don't really look at how the government obtained the power. You don't look at how the government is actually exercising this power, like how the government ensures effective control over the territory. Is it committing violations of human rights and humanitarian law in order to maintain the control? All these considerations are not really considered when it comes to the effectiveness approach. And that's why some authors started to criticize this approach, and especially in the 1990s, they started to suggest the democratic entitlement approach, whereby only a democratic government would be capable to speak on behalf of the state and would be capable to invite a foreign country to intervene in a civil war. Now, there are two main issues, again, with the democratic entitlement approach. On the one hand, the problem is, what does it mean to have a democratic government? Are we talking about a substantial idea of democracy, whereby democracy encompasses also all a series of protection and guarantees of basic human rights? Are we talking about procedural democracy, so are we talking about a government that was elected through free and fair election? And this obviously is something that we need to answer if we want to claim that only democratic governments can speak on behalf of the state. And then we have also another issue, like if we think about the governments that sit at the UN nowadays, we see that not all of them are democratic, not in the procedural sense or in the substantial sense. Some of them are considered like unlawful, not really unlawful, but are considered like regimes, and they're not democratic at all. So how do we reconcile this democratic entitlement approach with the coexistence of undemocratic governments that are generally recognized by the international community? So as we see, the traditional approaches suggested by the scholarship all have some issues, and that's why we should look at the practice of state to determine what's actually, like, whether we can actually reconcile these approaches. And if we look at state practice, we see that the way in which the government is recognized at the international level happens on two grounds. On the one hand, the international community tends to look at the way in which the power was obtained, and then once a government is recognized, the international community tends to look at the way in which the power is exercised. So now, if we think at the first, so the way in which the power was obtained, we see that from the analysis of state practice, we should distinguish between democratic government and non-democratic governments. When it comes to democratic government, generally speaking, we are talking about governments that have been elected through free and fair elections. If we look at state practice, we see that there are several cases when a government that was elected through democratic elections, like free and fair elections, tends to be recognized by the international community, even if there is an effective alternative, and even if it has never been in power before, or even if it has exercised the power only for a short period of time. And one example that can explain this position, and it's one of the most recent examples, is what happened in the Gambia in 2017. In the Gambia, there were the elections. The former president was running again for the election, but he lost the elections. So he was supposed to hand over the power to the new president, President Barrow. So what happened is that at the beginning, the former president recognized the results of the election, but then after a few weeks, he decided that he wasn't going to recognize the results anymore because he claimed that there were some issues and that the elections weren't really fair and there were some problems. So what happened is that then President Barrow, who just won the election, wasn't really actually not even the president yet, had to flee the country. He went to Senegal. From there, he was actually sworn in as a president. So there was a ceremony. He became the president. The international community, the UN, the majority of the states recognized President Barrow as the de jure president of the Gambia, and they did not recognize the former president, even if the former president had the effective control over the territory and the population of Gambia. And then what happened is that President Barrow, so the newly elected president, invited us, the ECOWAS, to intervene in order to regain power, and the organization accepted the invitation, intervened, and then Barrow could go back to Gambia. So here, this is really a clear example of a president who had never been in power before. There wasn't even a government. It was just one person basically who won the elections. And then this person was immediately recognized as the president, And then an intervention happened, and the Security Council endorsed this intervention ex post, saying that it was lawful and welcome what happened. So there are also other examples. I don't have time to go through all of them, but this I think is one of the most clear one. And then, as I mentioned before, in the international community, like in the UN and regional organizations, we also have a lot of governments that were not elected through free and fair elections. So what about those governments? Like, how did they ended up to be recognized as the government within the international community? And if we look, for instance, at the most famous cases like Syria or Libya, so Assad or Gaddafi government, in these cases we see that when they gained the power, there was no democratic alternative that could have been recognized as the jure government. And therefore, my conclusion here is that when you have a democratic government, an undemocratic government, and you don't have a democratic alternative, then this government usually is going to be recognized as the government of the state, and therefore is going to be capable to speak on behalf of the state and to ask for a foreign intervention if needed. So this is the situation when it comes to the identification of the government based on the way in which the power was obtained. But if we look at the way in which the power is exercised, does it have an impact on the consent power of a state? Like, if you have a state that commits, a government that commits gross and systematic violations of human rights and humanitarian law, does it mean that this government is not capable to ask for a foreign intervention? And when addressing this issue, it's interesting to look at the cases of Libya and Syria. So what happened in Libya and Syria is that, as we all know, there was the Arab Spring, a non-international armed conflict started, and part of the international community, in light of the violations of human rights and humanitarian law committed by the governments both in Libya and Syria, defined this government as unlegitimate representative of their own people, and attributed the legitimate representative of people, attributed this definition to a number of rebel groups. Now, the question is, what does it mean to stop being the legitimate representative of people? And is it like a legal, does it have legal implication, or it's only a political claim? And in order to answer, we can actually think at what happened in Syria when it comes to intervention upon invitation. Because in 2014, Syria invited the US to intervene to fight together against the Islamic State. And what happened was that the Obama administration decided to decline the invitation, also because they didn't want to get involved with a government that they considered illegitimate. And the US anyway intervened in Syria against the Islamic State, but it was on a different legal ground. It was collective self-defense on behalf of Iraq. So that was a very deliberate choice. They could have just intervened, saying, well, Assad asked us to intervene, and it's, you know, an intervention upon invitation, while they decided not to. And on the other hand, we have Russia. Russia intervened in favor of Assad. We all know about it. But it's interesting to see that the international community, like the states who define the Syrian government as illegitimate, they criticized the Russian intervention, but it was mainly because they didn't think that it was a good idea to intervene in favor of a government which is illegitimate. They never provided a legal basis as to why Russia should have not intervened in favor of Assad. And that's why this is one of the examples that led me to conclude that a government doesn't lose consent power when it turns against the population and it's considered illegitimate by the international community due to systematic violations of human rights and humanitarian law. However, the question here is, does it mean that a government, like a state, can always intervene in favor of a government that commits such violations? And the answer is not always, because there are actually other rules under international law that will prevent a state from helping another state which engages in wrongful acts. So first of all, an intervention in favor of a government that commits gross and systematic violations of human rights and humanitarian law under certain circumstances could amount as a case of complicity. And we have also Article 1 of the Common to the Four Geneva Conventions, which establishes a duty to ensure respect for humanitarian law, which means that if I'm a state and I intervene in favor of another state and this state is committing humanitarian law violation and I'm aware of this situation and I help this state anyway, I'm not really fulfilling my duty to ensure respect for humanitarian law. And then eventually we have also weapons law. Under weapons law, states are prohibited from allowing weapons transfer to states that engage in violations of human rights and humanitarian law. Therefore, even if a government that commits these violations retain the consent power, this does not mean that then a state can intervene and help this government all the time. So if we go back at the case of Russia, we can wonder whether Russia is actually has violated one of these rules that I mentioned. So is it a case of complicity, or has it violated the duty to ensure respect for IHL? However, this does not mean that Assad wasn't capable to speak on behalf of the state and to invite Russia. So to conclude, as we have seen, now the international community is increasingly looking at the legitimacy of governments as opposed to the effectiveness of governments. And this is something that is emerging in the practice of states. And in my presentation, I simply acknowledge what's happening in reality, but this does not mean that it's necessarily a good idea. Now, the problem is now that we have to wait and to see whether these rules are actually going to become part of positive international law in the future. However, obviously, the dangers of introducing these courses on legitimacy in interventions in internal conflicts, it's actually quite dangerous because legitimacy can mean anything. And what do we mean when we talk about legitimacy is something that there aren't really clear bases to decide what's legitimate and what's not. And therefore, for these reasons, we have to wait, but the situation doesn't look good.
Thank you so much, Chiara. I think something that's really profound to me about your work is I noticed as I was preparing to introduce you that particularly many pieces of scholarship recently published in the US by US authors seem to include consent unproblematically as one of the sources of lawful intervention. I think what's really powerful about what you're doing is both introducing this debate back into our contemporary discussions, but also not simply objecting to that through a formal interpretation of international law, but looking closely at state practice and asking that we talk about how we should understand what's happening in contemporary state practice. So we'll take questions and comments now, and I realize I arrogantly assumed you all know who I am. I am Naz Modirzadeh, the director of the HLS program on international law and armed conflict. So questions, comments? Yes.
Thank you. So that was a fascinating paper. So I don't know if it's exactly a question, but maybe a sort of a suggestion to think more about one particular issue, which is if international law does not incorporate human rights from the consent side, right? The human rights that are associated with democratic government, either procedural or in the way that it is exercised, but they are involved and included from the point of view of complicity, as you had in your last slide, right? Human rights with respect to violations of IHL, weapons law, and so on and so forth. We're talking about using the human rights discourse and the human rights idea in order to call an intervention unlawful, but it's a different type of unlawfulness, right? So human rights, to some extent, fail or do not articulate a self-determination or democratic governance type of right. So at the level of sovereignty, they're not enough. but they're still sort of a fallback option with respect to a more purely kind of humanitarianness, right?
Yeah.
So I guess my question is, how is it different to call an intervention unlawful depending on each basis, right? On one level, it's a very clear answer. One is jus ad bellum, the other is jus in bello. State responsibility kind of works in both ways. But yeah, the question is, how do we understand unlawfulness differently into this?
You mean differently in jus ad bellum and jus in bello, or?
And at the end of the day, what work does it do to call an intervention unlawful, falling back on these two different functions of human rights?
Yeah. So, well, when it comes to an intervention which is unlawful, when you look at human rights used to identify the democratic government, then in this case, the use of human rights is not really like the one use that determines whether an intervention is lawful or not. So the thing is that I will say that human rights are not really used to determine whether an intervention is lawful or not, but they're used to determine, they're a parameter of the legitimacy of government. And so human rights are not used to determine whether a government is legitimate or not. And then, once a government is legitimate, then some states are more prone to deduce that the intervention is lawful or unlawful. But it's actually two steps. So I think that, first you have human rights, then you have the legitimacy of governments, and then you have qualification of the intervention as lawful or unlawful. But the thing is that human rights in general are used as a parameter of legitimacy, and this is not always when it comes to interventions in internal conflicts, but it's more in general. Like if you think now about the situation in Venezuela, you still have discourses on what's legitimate, what's not, whether Maduro was democratically elected last year or not. And now there are also discourses on the possibility to intervene in Venezuela, but they're also only in a few specific countries, while other countries that are not considering the intervention are anyway engaging in discourses on human rights, legitimacy of the government, and how do you identify the legitimate government.
Thanks. Yes, in the back.
You mentioned that in the case of a state that might be engaged in gross and systematic violations of human rights, a third state's ability to intervene might be prescribed by those three different points that you mentioned, which is kind of similar to the previous question that we just had. So I guess I'm struggling a little bit to understand how, in the case of a state which is engaged in these violations, a third state could engage in foreign intervention in any way that doesn't fall within those three subcategories. I mean, I theoretically appreciate the distinction, but wondering what that might look like.
I mean, when it comes, for instance, to the case of complicity, the problem is that to have complicity, there are some debates as to whether, for instance, the state, I am a state and I'm helping you, and you're committing gross and systematic violations of human rights and humanitarian law. Now, do I have to know for sure that my help to you is going to be used to commit these violations, or do I only have to presume that my help is likely to help you committing these violations? Now, for instance, this is one of the main debates concerning complicity. So if you think, I'm just addressing this as an example, but if you think at complicity, it's true that we think, well, but if Russia is helping Assad and Assad is committing these violations, obviously Russia is going to be, there is a case of complicity here. However, the legal basis for complicity under international law are not so clear, and especially the criteria to determine when there is complicity or not are very unclear, and there are ongoing debates. So it's not, so automatic to say that if a state is helping the other, then there is a case of complicity, because you have to understand whether you need only knowledge of the commission of these violations, or you need the the intent of the intervening states to help the other state to commit these violations. So this is just an example to say that in theory, it's very difficult to imagine an intervention, like for instance, that Russia doesn't fall within any of these categories. But when in practice, how does it work? Like complicity or other forms of responsibilities are not as straightforward as they would seem. So.
Yes.
Yeah, thank you very much. Could you go back to the slide right twice, please? So, in the undemocratic government, in the absence of a democratic alternative in the general obedience of the general population, isn't that just, if that government can then ask for foreign intervention, aren't they just rewarding basically kind of very strong authoritarian states that have put the bulk of the population under their general obedience, right? So it's just perpetuating it. So if that's the case, what is the rationale for allowing foreign intervention there on behalf? Is it just a status quo?
Well, I mean, obviously, when I talk about general obedience by the bulk of the population in a civil war, you have to read it. Like, even now, Assad has the obedience of at least part of the population, because you always have part of the population who is for one side, and, well, usually most of the time. So what I meant here is that it has an effective control, so it controls at least part of the country and part of the population. The thing is that here, I'm not talking only about cases of intervention, I'm also talking about cases when you don't have an intervention. Like for instance, if you think about the case in Gambia, if you didn't have President Barrow that won the election, and let's say that the president simply decided, like the former president simply decides that there aren't going to be new elections, and so he remains in power, and he doesn't have a democratic alternative, so the international community is likely to say, well, okay, you're still, I mean, they might say, oh, this is, you know, this shouldn't happen, this is not democratic, but they're still recognizing this person as the president of the state, then in this case, this person would have the general obedience of, by the bulk of the population. And then if afterwards a non-international armed conflict starts, and then so you can claim that there isn't the general obedience by the population, then in this case, this government could ask for a foreign intervention because it will be recognized anyway by the international community.
Thanks. Yes.
Thanks very much, Liz. It's very interesting. I have two sets of questions. The first concerns the Security Council, and the second concerns the provision regarding ensuring respect for IHL. With respect to the Security Council, how do you think we should assess whether or not the collective security system and the role of the Security Council in relation to this topic is succeeding or not? And do you have any ideas on how the system could be improved and who would benefit from improving it? And the second question is, what's your view as to where the current law is as it, in terms of requiring states to do what in relation to whom concerning the ensuring respect for IHL? So where's the law today, do you think? Like, where's the best statement of the law?
You mean
On Common Article 1.
Common Article 1, ensuring
okay.
respect for IHL.
Okay. So when it comes to the Security Council, I think the main issue when it comes to interventions in internal conflicts in general is that at the end of the day, the states that decide to intervene and the states that decide to intervene in favor of whom, that's very political. So we can identify legal rules that determine when it's lawful to intervene or not, but then ultimately it's really like a political decision of the state to intervene or not, or to do something. And I think the same can actually applies to the Security Council, and obviously it's an ongoing debate that I'm not sure it's ever going to end, or I'm not even sure whether we can actually identify ways to change the system, because in these cases, my feeling is that we should have rules determining like how to identify the government in certain cases. And it's true that sometimes the Security Council intervenes, like issues a resolution and say, oh, this is the government, or oh, we welcome, or we welcome this intervention, like ex post. And the thing is that my impression is that the Security Council isn't really following any specific rules, but it's mainly based on what's happening in that specific moment. And the Security Council is actually following what I call the international community, which is basically the majority of states, and this includes also the UN and the Security Council. So the Security Council falls within this trend. So when I reach these conclusions, I also consider the reaction of the Security Council to this situation, like for instance in the Gambia and similar cases. But again, lacking clear rules, I've never really seen the Security Council thinking about, so what are the rules, like how are we recognizing a government or not? What about the Estrada doctrine, which says that states recognize states and not governments, which seems completely, forgotten, and unless it's convenient to mention it because a state doesn't want to take a stand on a particular issue. So yeah, I mean, I think that Security Council is actually falling within these. And when it comes to the duty to ensure respect for IHL, it's actually, like I mentioned it as one of the rules that could ground a basis to say, could be a violation. But what does it mean in practice to ensure respect for IHL? It's very complicated, especially when it comes to whether the states have to do something actively to ensure respect for IHL. So in this case, it's difficult to say, so to what extent a state should do something to ensure respect for IHL. But here we're actually talking about not doing anything. Like if you don't provide weapons, for example, which also falls within the weapons law, but if you are providing weapons to a state that commits humanitarian law violations, are you actually violating the duty to ensure respect for IHL? And there is actually part of the scholarship, and I agree with them, that claims that this will be the case, because you are actually doing something which is not going to help, which is not preventing this violation. So,
Yes.
What about situations where the shoe is on the other foot? So an outside state is deciding whether or not to intervene. And here, to broaden it out a bit, you were talking about legitimacy before. So like in Madagascar, like France, which had a prior colonial relationship, and the entire OECD basically forbade foreign investment until Madagascar, the government that was in there was military, staged elections in 2012. So my question has to do with outside states that say it's illegitimate, and so we won't allow foreign investment, and the other part of that would be sanctions. How are those things forms of intervention, in this discussion?
yeah, I mean, so I focused mainly on intervention, like armed interventions.
Correct.
Obviously, when it comes to other forms of intervention, the issue is, like as you mentioned, like there are also other interests that the state has. Well, this is something that I'm afraid international law has to accept at some level. So, like, whenever you have an intervention in an internal conflict, or whenever you have a state that says this government is not legitimate, or I decide to support this government as opposed to another one, it's it can be done on legal grounds, and states usually try to justify it on legal grounds, but there is always there are always political implications, and especially when it comes to France. France has a long tradition of intervening in former colonies, especially in Africa. So if we think at the intervention in Mali or in Central African Republic, and why France intervened in Mali and Italy didn't? Well, probably because Italy didn't have a colony and Mali was a French colony. So obviously we cannot deny these bonds and these relationships between states that we still see nowadays. So, and they're still strong for, I think, understandable reasons. So, but what I believe is that at the end of the day, international law can set some standards of behavior, and then the reason why someone does something or not is actually beyond that. It's like if you think about criminal law, you cannot kill people under criminal law, but why do you decide not to kill someone, or why you decide to do it anyway? Well, that's really like a personal choice. And I think that the same applies anyway in the relationship among states.
I think I'll take moderator's prerogative and ask one question too, which is, I wonder, in the reading that you did, what was your sense? So you framed the abstention notion as being, I don't think you said it's no longer good law, but it had the sense that it's increasingly unpopular as an accepted option. And I'm wondering to what extent all of the analysis that follows in some way assumes that that's the case, right? That abstention approach is no longer a valid one. And did you have a sense in your reading that, well, one, there seem to be a consensus that rule, if it ever existed, really is no longer even a rule, regardless of whether state practice has practically undermined it? And two, is that principled position of unlawfulness, even if you actually know as an international lawyer today, it's not likely to be accepted as a rule as such, does it provide you with the ability to have a discussion about this that says, in fact, this is about power, or this is about politics, or really when we're talking consent, it's not all of these subcategories, but it's rather just the fact that the powerful intervene when the weak cannot actually deny their ability to intervene. So I guess my question is, what work does that abstention idea continue to do today, even if we agree that it doesn't seem to be very powerful law anymore?
So regarding the readings, there are actually some scholars that even nowadays claim that there is this rule under international law whereby it's unlawful to intervene in an internal conflict.
No matter what.
No matter what, with the only exception of counter-intervention. But the scholar that actually made his position famous was Dosvalbeck, who wrote this article in 1986 on interventions upon invitation, and she made a very strong argument in favor of the abstentionism approach. And I think she influenced a lot the discussion in the scholarship, and since then several scholars just accepted her position because it's a very convincing article. And probably in 30-something years ago, that was actually the case. But then what happened is that if you look at the scholarship in the 1990s, it's actually more about effectiveness or democratic entitlement. So you had the articles by Frank on all the democratic entitlement discussion. So that's really about the scholarship per se. But even nowadays, there are actually authors that say intervening in civil wars is unlawful, and they quote Dosvalbeck. So that's generally speaking. And that's why I felt also that, I should take into consideration this position, even if I don't think that it's the law anymore. And when it comes to the other issues, so as to whether shouldn't we just say, if I understood the question correctly, like, shouldn't we just say that the abstentionism approach is still valid, and then states do whatever they want because it's a matter of power, basically? Well, the thing is that when it comes, I mean, there is also a consideration regarding customary law. Like when the majority of states behave in a certain way, you have the Security Council, the UN in general, that actually seem to believe that this is the rule. Then, yeah, maybe at the beginning it was mainly, you know, if you think about the democratic interventions of the UN in some Latin American country, then there you might claim, you know, in the 1990s, you might claim, well, this was actually an exercise of power by a powerful country in other less powerful ones. But once this becomes a pattern over the years, and it's been basically 30 years, then I think that we can actually say that things are changing besides political considerations. Or
Great, thank you. Any other questions? Well, please join me in thanking Dr. Redaelli.